So please, as I stated, you are welcome to our Easter conference. For the purpose of this conference, we shall be doing a very thorough examination from the Gospels. That is from the books of Matthew, Mark, Luke, and John. We are not doing this from a theological perspective, but rather from a legal perspective. What we seek to achieve is to answer one simple question: whether the doctrine of natural justice was upheld in the trial of Jesus Christ. And if not, as persons, as stakeholders, as a family, as individuals, as leaders, what lessons can we take from the story to enhance our engagement with other people, whether as their leader, as a parent, as a partner, or even what lessons can we take to enhance our decision-taking as a person? For the purpose of this presentation, the main takeaway today is you should be leaving this conference with education on one thing: how you can personally construct a wheel, a model, or a structure for adjudication of complaints in your home, in your firm, within the circle of your friends, which will uphold the doctrine of natural justice. So to do so, we shall be studying the topic from three angles. One, we shall address natural justice from a legal perspective. Two, we shall construct and deconstruct the story of the trial of Jesus Christ within the perspective or within the legal framework of natural justice. And three, we shall be studying how, as persons, we can easily construct a wheel for adjudication of disputes in a small firm. So it may be a family, a nuclear family. It may be a small shop you own, or it may be the circle of your friends. So let's move to the first aspect, the concept of natural justice. When we say the concept of natural justice, we are actually looking at three things. There are three salient elements of every legal system or every adjudication process or every decision-taking route which establishes the doctrine of natural justice. The first being that natural justice establishes the quality of justice. So every passing day, we take a decision. It is possible that you woke up this morning and you decided to block somebody from your phone. It is also possible that you woke up this morning and you decided to dismiss a worker of yours. It is possible that today you were in court sitting as a judge, with respect to our honorable judges here, sitting as a judge, and you made a decision governing the future of a claimant, an accused person, or of the state. In all these processes, there is some sort of justice. But the question we will ask ourselves is how quality, or what is the quality content of your justice? Before we can assess the quality content of the justice you actually meted out, we have to use one litmus test, whether or not the doctrine of natural justice was upheld. On the second note, the doctrine of natural justice focuses on the quality of the adjudicator. That is the person making the decision. Before you can call yourself a just and honorable judge, you should have passed through a meal. And that meal should establish that you understand the doctrine of natural justice. The doctrine is so basic that you pass through the meal every second. Every day you sit to make a decision. You may be working as a manager and you may have to decide on complaint letters. Whenever there's a letter on your table, you are actually in the mill. Whatever decision you take creates a picture of you, whether you have the quality of an umpire. The third point you need to know under the concept of natural justice is it is actually a satisfactory standard. Normally, during the period of adjudication, it is very, very difficult to have the prosecutor and the prosecuted being satisfied. But this is just one of the few occasions where you have satisfaction from the point of the prosecutor and the prosecuted. The person on whose behalf a decision is taken should be happy with your decision. The person making the decision should be happy after making the decision. And the person suffering from the decision should feel that justice has been done, should feel that justice has been made. So when we look at it from the perspective of natural justice, we are examining 3 points. 1, the quality of justice. 2, the quality of a stakeholder for justice. And 3, the standard of satisfaction. At the end of the day, can the prosecutor say, I'm satisfied with this decision? Can the prosecuted also say so, that I'm satisfied with this decision? When you have all these 3 coming together, then you are likely to argue that the doctrine has been upheld. But the doctrine of natural justice has 2 primary elements. Before we can claim there's natural justice, there are 2 elements we should be studying. And those elements are expressed in Latin maxims. The first element being what we call the odi authorem partem, which means as a judge, you should hear both sides. It should not be the case that a report has been lodged against one of your workers and you instantly make a decision. Before you proceed to reach a decision, you should have heard the stories of both parties. The second element of natural justice, which is expressed in Latin as nemo iudes in causa sua, means a man should not be a judge in his own cause. What this means is that when you are making any decision in the house, you should not have any motive other than the interest of justice. We are looking at it from the very basic decisions we make in our houses. The decision to take your child to a school, the decision to cook a certain meal in the house. It may be at your workplace, the decision to pay your workers an allowance at the end of the month. When these decisions come before you to take, if you want to be a just judge, your only interest you should have when making the decision is that of justice. But when we talk about hearing both sides, it is very interesting because in almost all decision taking, there are communication. So you may have somebody saying that, after all, I got the opportunity, or I gave him the opportunity to speak. Remember, we have previously emphasized that natural justice looks at the quality of justice. It is not the point that you heard the side of the other party, but we are looking at the quality of the circumstance surrounding the trial. So before you can be said to have heard both sides, you need to be able to establish 4 major points. The first point is you should have given your opponent or the party being put to trial a reasonable opportunity to be heard. That means simply that the decision you may have taken from your house, that when I get to the workplace, she will see what I'll do to her. When you get to that workplace and you request of the person to state her story, you have not heard both sides. The law requires you to give the party a reasonable opportunity to be heard. And that includes a reasonable opportunity to prepare. So, acting as a reasonable man, you are expected to communicate to the person that tomorrow I shall decide on a complaint which has been leveled against you. So prepare adequately to give me an answer. Impromptu requests for answers will not suffice, but rather we are looking at a situation where a person is given the opportunity to prepare and also the opportunity to be heard. Again, an opportunity to be heard includes an enabling climate to be heard. Whilst working as a police officer, when you have a complaint and you request of a suspect to tell his story with a slap, you have not heard both sides. The person may speak, your ears may capture the voice of the person, but you only be considered to have heard both sides if the climate is such that a reasonable man will independently state his story. If you find yourself in a situation where, or a situation of hostility, where you request a party to tell his story, you haven't heard both sides. Meaning, as parents, if before you ask your child to explain how come a meat got missing from the soup, you have given the child a dirty slap, you have not heard both sides. As businessmen, if before you request of your worker to explain how come you are making a loss, but before that you tell the worker that no matter what, you are going home, you haven't heard both sides. The interesting thing about hearing both sides is actually the fact that the balance should tilt in the favor of the person standing trial. When I say that, it means that you, as an adjudicator, should be ready to support the person standing trial in establishing his defense. That means if you work as an architect and you are studying the work done by a worker, you are making a report or an analytic report on a construction done by somebody, you will not be considered to have properly heard his side if you do not make provisions for visualization of his point, because we know architects normally deal with drawings. So if you have your trial such that the person will have to speak to a drawing without giving the person the opportunity to visualize the drawing, as known per your profession, you are not considered to have heard both sides. Now, when we say a person shall not be a judge in his own cause, what we mean is that for you to consider yourself as an unbiased judge, it means you have only one interest, the interest of justice in accordance with law. Normally, we have a lot of expositions of the law saying the judge should have only one interest, which is the interest of justice. That is not sufficient. It should be the interest of justice in accordance with the law. Meaning, seated as a judge, you should not occasion any conflicting interests. The conflicting interest may be a personal interest. So you may be somebody who is a strict vegetarian. Assuming you are seated as a judge of a case involving another person killing an animal for dinner, this is a clear case of a conflicting interest, especially when there's evidence of you saying somewhere that if you see people eating meat, you feel their rest home should be the prisons. It means the person standing in front of you has two legs in the prisons and the person only needs an exit from you. Also, your interest should not be based on relationship. So you find a situation where, personally, I have very good friends here, where there's a trial involving a friend. And you know personally that looking at the nature of your relationship with that friend, you will not do justice. Your interest should not be material. Assuming you are working as a businessman and there's a complaint against your highest paying client, you may have to make a decision concerning that highest paying client. You are likely to be biased. So, seated as a judge, you are deemed to have projected the ends of justice if you hear both sides and if you are not biased. But let me put this caveat here. In terms of not being biased, it does not mean that a judge should behave like an island. Because no matter what, a judge will be a Christian, maybe attending church, a Muslim. The judge, even being an atheist, may have friends, or a Buddhist attending the temples of Buddha. Definitely, you have friends. Before you can be a judge, you may have gone through some form of education. So it is not the case that a judge should not have friends, but we are looking at a situation of a real likelihood of bias. Meaning, being put into the position of the judge, or if a reasonable man is asked to sit on the chair of the judge, that reasonable man will have an interest other than projecting the ends of justice. But having said all this, we should know, for the purpose of developing our story, that there are three exceptions to the rule of natural justice. Meaning there are three situations where the court or the law will overlook an action done by a biased judge, especially. These are three special situations where maybe it may be clear on the face of the story that this judge was a biased judge. But the law will have no option but to overlook that. The first situation is what we call the waiver of rights. We need this background because when we get to the story of the trial of Jesus, we may be talking about these three exceptions. The waiver of rights. When we say waiver of rights, it literally means that a person fails to assert his rights. The person standing trial fails to raise an objection. So assuming you are standing trial against a party and you are aware that that party's wife is the judge, you are expected to speak out. If you fail to speak out, you are deemed to have waived your right. So inasmuch as natural justice was not upheld, you cannot challenge the legality of the decision being taken. So you may have a situation where your mother is making a decision concerning a school you should attend. You are very much aware that the headmistress of a preferred school is your mother's best friend. You are expected to speak out. If you fail to speak out, you are deemed to have waived your right. The second exception is that of necessity. Necessity literally means there's no availability of substitute for a judge. So assuming in your house, the person who takes decision concerning the food you eat is your mother, there's no substitute for that. Meaning, if your mother has to decide the food you are taking for lunch, even if you raise an objection, the question is, who will then take the decision? There's no substitute. In formal terms, you may have yourself be in a location where there's only one judge. Assuming the COVID-19 times, all the judges in the Republic of Ghana decided to travel for a conference, and there was a lockdown, maybe in Australia, leaving only one judge in Ghana. It does not mean that adjudication cannot go on. That judge may be biased, but it may be necessary to allow the judge sit, because without the judge, there will be no hearing. The third exception is legal authority. When we say legal authority, we mean the law has specified that a specific person should take a decision. Meaning, in the absence of that person, nobody can take the decision. Indeed, if you allow another person to take the decision, then you have breached the law. Remember that I stated that natural justice is justice in accordance with the law. That's what I meant. So if the law says that in a certain defined situation, a decision should be taken by Mr. X, meaning without you involving Mr. X, the decision will be considered as a void decision. Let me give you a basic example within the customs of Ghana. In most customs, before you can have a person being nominated and installed as a chief, that person should be nominated by the Queen Mother. If you bypass the Queen Mother because you believe that the Queen Mother has a specific interest in a candidate, you have your candidates or your installed chief being a fraud chief or a void chief, because the customs specify that only one office should engage in the nomination. So for the purpose of the law, note that today's discussion will straddle along these two lines: whether a side was heard, whether there was a biased judge, and if it be the case that there was a biased judge, whether or not these three exceptions may step in to cater for the legality of the trial of Jesus Christ. Now, we may be thinking that the concept of natural justice is too formalized and legal, and it has no biblical backing. Let's look at all the authoring pattern. The best example we can use is the trial of Adam and Eve after they flouted the instructions of God in the Garden of Eden. Please help me with Genesis 3:11 to 13. Please, let's carefully look at how God approached the trial.
Genesis 3:11 to 13, verse 11. The Lord God said, "Who told you that you were naked? Have you eaten fruit from the tree I commanded you not to eat from?" 12. The man said, "It's the fault of the woman you put here with me. She gave me some fruit from the tree, and I ate it." 13. Then the Lord God said to the woman, "What have you done?" The woman said, "The serpent tricked me. That's why I ate the fruit."
Thank you very much. So, even the basics of creation, according to the Bible, God, during the trial of Adam and Eve, with his attribute as all-knowing, did not just proceed to say that you have eaten from the fruit, so therefore you are banished. When you read 11 to 13, you realize that there was an opportunity to be heard. That he put questions to the man and the woman, soliciting for answers. Now, if you want another evidence of the biblical perspective of all the authoring pattern, hearing both sides, you may want to also check the trial of King Solomon involving the two mothers who were making claims to a child. You realize that King Solomon gave them an opportunity to be heard. Now, you may also be thinking that looking at the Bible, especially from the point or from the authoritative nature of God, then in terms of biased judges, the Bible may permit judges to be biased. That is not the case. In the book of Deuteronomy, when God was giving Moses the instruction to create or to appoint judges, this was the specific instruction given to Moses at Deuteronomy chapter 16, 18 to 19.
Deuteronomy 16:18 to 19. 18. Appoint judges and other officials in every town that the Lord your God gives you. These men are to judge the people impartially. 19. They are not to be unjust or show partiality in their judgment, and they are not to accept bribes, for gifts blind the eyes even of wise and honest men, and cause them to give wrong decisions.
Thank you very much. So from these two provisions, there are other provisions we may actually consider. But from the authority of these two provisions, we will have to come to an understanding that the doctrine of natural justice is so basic that it even deals with the Christendom understanding of adjudication. The next angle we shall be moving to, now we have laid the foundation for natural justice, is before we study the trial of Christ, we have to understand the political and legal system which existed during the trial of Christ. Because if we are not careful, we may be thinking that during the trial of Christ, there was a certain Supreme Court like we have now. So whatever happened dealt with chiefs exercising criminal jurisdiction. We know in most systems, including the Ghanaian system, traditional leaders do not have any criminal jurisdiction. So we have to understand the trial of Christ from the political and legal system which underpinned the society during the days of Christ. So that will be the next thing we shall be looking at. So let's look at how we can create a context of the political and legal system which existed during the days of the trial of Christ. Now, note the first thing you need to note is that during the time of the trial, the Jews were under some form of captivity. So if it is within our modern times, we will say colonization. And they were under the rule of the Romans. I said some form of captivity because even though there was some form of colonization, they were allowed to practice their laws and ideologies, but to a certain extent. That is to the extent that they won't offend Roman laws. So note that at the time of the trial of Christ, there were actually two existing legal systems, the Jewish system and the Roman system. Only that the Roman system was paramount. That is, if you want to check the legality of a decision taken by the Jewish system, you have to juxtapose it with the Roman system. That's the first thing we have to note. So the Roman system basically was being led by Caesar Augustus. So if you remember your Bible very well, or if you have heard the story, which is a popular jargon we say out there, give to Caesar what belongs to Caesar. That was an answer Jesus gave when he was asked whether he should pay taxes are legal. Also, if you remember your story of the birth of Christ very well, you remember that, or you notice that it was at a time where a certain system felt shaken, that they wanted to kill all male children because they felt their kingdom was under threat. Yes, it was the Roman system. Now, within those times, what you have to have at the back of your mind is assuming that system was the Ghanaian system. In as much as we can practice Ghanaian customary laws, we are still under the ordination of a higher power, which is the Roman system. And that is established in Luke chapter 3, verses 1 and 2. Add Luke 3, 1 and 2.
Luke 3, 1 and 2. It was the 15th year of the rule of Imperial Tiberius. Pontius Pilate was governor of Judea. Herod was ruler of Galilee, and his brother Philip was ruler of the territory of Iturea and I don't know. Trachonitis. Lysiana was ruler of Abilene. 2 and Nanas and Sapphira were higher priests.
And Annas and Caiaphas were high priests. So from this Luke 3, 1 and 2, it gives us a fair idea of the picture of the Roman system or the legal system which existed at the time of the death of Christ. So note that if you are supposed to create a diagram of the system, you have Caesar Augustus as the person on top. So like you find on the screen, he was the head of the Roman system. In another discussion, we'll go to the position of Caesar. If you have read your literature on Julius Caesar, you will know or you understand why Caesar Augustus was so revered. He was actually considered as a half-god at that time. But underneath Caesar Augustus, we had what we call the Sanhedrin. The Sanhedrin were basically the Jewish leaders. We'll come to a discussion of the Sanhedrin later. So like I stated, if we are looking at it from a Ghanaian perspective, then our Ghanaian leaders will be called the Sanhedrin. Then our Ghanaian leaders will be called the Sanhedrin. Also, under the Roman system, there are two leaders or two systems we have to consider. One was that of Pontius Pilate of Judea. When you examine the activities of Pontius Pilate, you realize that he was an autocratic leader. He believed in autocracy. Indeed, the Bible describes him as a prefect appointed by the Roman kingdom. So Pontius Pilate, even though he was autocratic, had his powers underneath or subservient to the Roman system. At the other side, remember Pontius Pilate sent Jesus to Herod. We had Herod Antipas of Galilee. Now, one interesting thing about the Herod family is that they were a monarchy. So there was Herod the Great. Herod the Great had his brothers and some of his children being leaders of parts of the legal system. So note that the first thing you have to know before we even proceed is that from the context of the political system, during the time of the trial, there was a superpower, Caesar, leading the Romans. But underneath Caesar, within the context of the trial, there was the Sanhedrin, that is the Jewish leaders. They were practicing theocracy and aristocracy. That is, they were practicing the rule of religion and the rule of the powerful elites in the society. There was also Pontius Pilate, who was noted to be an autocratic leader. And lastly, there was Herod, who came from a very good structure of a monarchy. So Herod's system in Ghana now can be likened to maybe the chieftaincy system, the monarchical system. Within the UK perspective, the Queen of England, or now we have the King of England. So that's the first thing we have to note, the political system which existed. Now let's go through the Sanhedrin, because the Sanhedrin is actually the bedrock for the trial. We have to understand some elements which the Sanhedrin possessed as at that time. Before we can proceed, without going through those elements, you may not understand why the Bible will say that there were quite a lot of elders which gathered to try Jesus. So before we can understand the trial, or before you can ask yourself, why is it that in some parts of the gospel it is stated Jesus was tried at night? Then another writer states Jesus was tried during the daytime. Why do we have that sort of disparity? Or whether or not even there was a disparity? When we say the Sanhedrin was basically classified into three. So for the purpose of adjudication, we'll say three courts. There was the Great Sanhedrin, made up of 71 men. So when the Bible says elders gathered to try Jesus, do not think that how come in our courts of today we have one judge, but elders gathered? Even some of the books say that religious leaders and elders gathered. Note that there was a Great Sanhedrin. The Great Sanhedrin was made up of 71 men. Now, the Great Sanhedrin exercised three primary powers. One, offenses involving blasphemy. Two, offenses by or against a tribe. And three, offenses by or against the high priest. When you check Numbers chapter 11, verses 16, you read the direction God gave for the assembling of the Great Sanhedrin. So you will find out that the Great Sanhedrin was composed of not only religious leaders, but also businessmen. When we proceed, you understand why the Great Sanhedrin will go after Jesus when it was composed of businessmen and religious leaders. When I say businessmen, the heads of the society. Now, we also had a lesser Sanhedrin. So within our system, we will say a court of lesser jurisdiction. They were composed of 23 men, and they exercised other criminal jurisdiction aside the powers given to the Great Sanhedrin. For information on the lesser Sanhedrin, you may want to read the books, the Jewish books, like the Mishnah Sanhedrin 1 and 4. But we don't need it. We don't need that for our discussion, because whatever happened was within the ambit of the Great Sanhedrin. We also had a court with 3 judges. Now, that court with 3 judges was formed, made up of adjudicators. They exercise civil jurisdiction and other criminal jurisdiction like defamation. What you need to know is that defamation those days was a criminal charge. It wasn't civil like we have now. It was a criminal charge. So the Great Sanhedrin had criminal jurisdiction. They tried people for crimes, lesser Sanhedrin for crimes, but for civil trial, it was done by the 3 judges. And they exercised some petty criminal jurisdiction like that of defamation. Remember, I've stated that defamation within the Jewish context was a crime. That is, to make a statement which tarnishes the image of another was a crime. Now, we have to also understand the procedural rules which applied to the Great Sanhedrin. When I say the procedural rules, what I mean is when the Great Sanhedrin sits, what are the procedural rules which govern their sitting? Because now, if you decide to file a case in any Ghanaian court or any foreign court, you may have to go through some procedure. You cannot just appear in court in a day and you have a judgment. There were certain key procedural rules which we have to study for the purpose of the trial of Christ. The first rule you need to know is that a person can only be found guilty on direct evidence. When we say direct evidence, it means somebody testifying that I saw him when he was doing it. There was no avenue in terms of trials which are punishable by death for a person to be convicted on his own confession. So when an accused person appeared before the Great Sanhedrin and the person is standing trial for an offense punishable by death, he was expected to be quiet. They rather needed to establish evidence to show that he did A and B, and the evidence must be direct. You must have seen or witnessed the person committing the crime. Secondly, because we are saying the evidence is direct, the law did not permit circumstantial evidence, meaning you cannot infer from evidence that the person has committed a crime. What that means is, if somebody is dead in a society or in a community, a Jewish community, and you see another person with a shirt filled with blood, that person cannot be prosecuted for murder. You cannot infer that since we saw blood in your shirt, you committed a crime. If the offense is punishable by death, you only require direct evidence. The second point you need to note, all these points, we shall analyze them within the trial of Christ. The second point you need to note is that for the Great Sanhedrin, they can only sentence a person to death where there's more than one consistent and corroborative testimonies. When we say consistent and corroborative testimonies, it means that if the only witness we have is one person testifying that I saw her committing A, B, and C, that will not hold water. When we get to the trial, I'll demonstrate that to you. It can only be through the testimonies of 2 people. And the 2 people actually, or 2 or more people, were supposed to be men who met certain characteristics. So note that the rules were so strict that it was not easy to put somebody to death. Reason why the trial was a very special trial, because when you read the books, it looks so easy that they easily put Lord Jesus Christ to death. But that wasn't supposed to be the case. 3, the Great Sanhedrin only sits in public. There was no room for in-camera sitting like we have today. The basis for that is that because they are just 71 men, there was the possibility that they may gang up against somebody. So they needed to sit in public for the public to witness whatever was going on. The next, which is very interesting to the trial of Christ, is where the offense is punishable by death. They could not reach a unanimous decision. They could not reach a unanimous decision. When we say a unanimous decision, it means all 71 men cannot say the person is guilty. From the Jewish perspective, when you read the Talmud, which includes the arguments by Jewish professors, the explanation they give is if they are unanimous, then there's a presumption that they have ganged up against one man. There should be somebody there who will say, no, I do not agree. Then the last point to note, which actually explains why some of the books say Jesus was tried in the night and another says Jesus was tried in the morning, was that when they reach a decision based or a majoritarian decision, they cannot there and then make or pronounce a punishment. They have to close sitting and reconvene in 24 hours after a full day for those who held the person to be guilty to reaffirm their position. Those who held the person was innocent, they are now safe. They will go home. But if you stated, I think he was guilty, we are giving you one full day to appear before us to tell us that I think he's still guilty. The purpose for that is to take a life of somebody was actually seen as a serious form of punishment. Remember that the Jews are being governed by the 10 Commandments primarily, and it contains thou shalt not kill. So before they will proceed to rule that a person is guilty of murder, then you have to be very sure. That is why the rules actually from the Talmud, the arguments being made is that they could not reach a unanimous decision. Immediately they reach a unanimous decision, the picture being created out there is that no, these people have ganged up against one man. And it made sense they could not reach a unanimous decision because the Great Sanhedrin was actually assembled from the heads of the various tribes of the Jews. So no matter who the accused person is, that person's head will be seated there. Also, from important personalities in the society, those days their population was not that large. Definitely you have connections, you know somebody. There should be somebody there who is ready to stand the fort for you. But if we realize that they all want you killed, their rules state that free the man, you guys have ganged up against him. So that is what we need to have at the back of our mind. That when we say the Great Sanhedrin, we are looking at people who required only direct evidence. There must be corroborative evidence. The trial must be in a public space. And for trials punishable by death, they could not reach a unanimous decision. And even if their decision was made on a majoritarian count, they were supposed to disperse and reassemble after one full day for the people who held the person guilty to reaffirm their decision. So please, let's have that background at the back of our mind. Now, one thing we have to also note is that aside this whole trial, perspectives also matter in the society. Just like how in our society we have, even in your classroom, you have people you call anti-so, people who will not like to mingle with others. You have people you classify as always being in the pocket of lecturers. So was the Jewish community. We have to understand the composition of the Jewish community. And from that, we understand why they approach the trial of Jesus within or from that angle, from the angle of hostility. Note that at that time, even now, it is still said that the Jewish community was made up of 4 primary compositions. That is in terms of the population. The first being the Sadducees, or the Sadducees. They were the wealthy and the pragmatic people. Indeed, in some books, it is argued that they were atheists. It is not true. They were not atheists. They were actually people who supported the kingdom business. Only that they were very rich and pragmatic, and they liked to possess power in the society. When we delve down, you understand why the great Sanhedrin rose against one man. Because remember, I stated that they were composed of not only religious leaders, but persons who could be classified as elders in the society. Yes, the Sadducees were part of the great Sanhedrin. Also, we had the Pharisees. For the Pharisees, they are very popular because they enjoy some very good old bashing from Jesus Christ. They were the theologians, and they believed in idealist spirituality. So in our context, in our normal day life, we would call them the Creface. So they were the people who considered themselves to be living a very righteous life. Jesus classified them as judgmental people, people who thought of themselves to be upright before God, so were not so humble before the throne of grace. Note that these first two people, the Sadducees and the Pharisees, they were actually the key components of the Great Sanhedrin. We also had the Essenes people. They were basically the introverts. Now, when you read the composition of the Jewish community, they still have people like this. They are reported to stay far from the city. They live an outcast type of life. Now, if you want to know how they lived, read the description of the Bible of John the Baptist. You realize that the Bible describes him as a man who moved away from the people. He stayed somewhere outside the confines of the society. Now, their key nature was that they called for liberation, but they called for liberation through conscientizing people of the gospel. So if you look at the ministry of John the Baptist, he was talking about the kingdom of God, how the kingdom of God will free his people. Now link this to what we stated previously, that within that political system, there was some form of colonization, and you understand why these people were actually seen from a very negative angle by the Romans, because they were telling people that there's a kingdom coming one day. There's a king coming one day, and that king will take you from this form of hostility you are being subjected to by the Romans. And of course, as evidence of the dislike to these people, we all know how John the Baptist lost his life. That it was just through a request for his head at a party, and that request was done. Then we had the fourth group, the Zealots. Now, the Zealots are the people who we will call in our modern day society as freedom fighters. They are the people who will argue that we do not need to be under the control of anybody. Indeed, when we get to a chart by the Romans after Jesus rose Lazarus from the death, you will note that Jesus was classified in their heads as a zealot, because even before Pilate, they told Pilate that this man is rising or is assembling the people against you. The difference between the zealots and the Essenes was that for the zealots, they were persons of action. They were radical people. You know the story of Jesus visiting the temple and collapsing tables when they were doing business at the temple. Yes, they were the zealots. If it was an Essenes, he would preach to the people that no, this is not within the lines of Christ. The zealots like things done. Now, to establish the presence of the Pharisees and the Sadducees, let's look at what Jehoshaphat did when he was appointing the Great Sanhedrin. Now, from this, you will note that the Great Sanhedrin is composed of the Sadducees and the Pharisees. Adrian, 2 Chronicles 19:8. Add.
2 Chronicles 19:8. In Jerusalem, Josaphat appointed Levites, priests, and some of the leading citizens as judges in cases involving a violation of the law of the Lord or legal disputes between inhabitants of the city.
Thank you very much. So you look at the composition very well. The judges were Levites, persons who were basically servants of the temple, the priests themselves, and some of the leading citizens. So they were basically the Sadducees. They were the people who were making the decisions. Actually, in some versions, it reads as some of the heads of the tribes. So please note that in terms of classification of citizens, these were the classifications. If you understand this, you understand why it's these people treated Jesus Christ that way. Because there was a preconception, of course, backed by prophecy. There was a preconception in their heads concerning the type of Jew he was. Also, we have stated that the people who tried Jesus were the great Sanhedrin, and they were composed of the rich, the mighty, the society, and the theologians, the people who believed of themselves to be spiritually ideal. Now, the next thing we have to deal with is basically the charges leveled against Jesus Christ from a legal perspective. So we will soon learn that Jesus Christ was not tried based on only one charge, but from an analysis of the gospel, you realize that 3 charges were actually leveled against him. And the 3 were dependent on the jurisdiction or on the court during the trial, whether the great Sanhedrin or before Herod or Pontius Pilate. Let's look at before the Sanhedrin. The charge of blasphemy was leveled against Jesus Christ. When you read the books, especially from John 10:30 to 39, you will notice that there's a very popular statement we make, but most of us do not even know what happened after Jesus made that statement. Jesus stated that I and my Father are one. You may want to check what happened after that statement. He was nearly stoned to death because he was considered to have equated himself to God the Father. That as a man, are you saying that you are God? And within the context of Jewish lines, that was blasphemous. Another statement Jesus made, which was actually used against him, was at the temple. When he told them that in John 2:19, that if you break this temple, I will rebuild the temple in 3 days. It was considered blasphemous. Blasphemous from a religious sense. Also, actually, that statement also had a political connotation because that temple was actually built within the course of years. So they were like, we took years to build this temple. How come you are coming in to say 3 days you shall rebuild it? But from the context of the Jewish laws, that statement was considered blasphemous. Now, before Pontius Pilate, Jesus was actually charged with 2 counts. One was a charge of treason, and 2 was a charge of sedition. With respect to the charge of treason, remember the triumphant entry into Jerusalem. When the women laid their cloth on the road and they called Jesus the God, or they stated that God bless the coming of King David. God bless the coming of King David. Before Pontius Pilate, the argument being made is that this man is saying he's the king and not our Caesar. And that statement was considered as Jesus rising against the Roman kingdom. Also, remember when the adulteress was being put to death. If you read a Bible from John 8:3-11, you realize that they actually put Jesus to a test. Because they told Jesus in the Jewish laws, when a woman commits adultery, she has to be put to death. And Jesus rose up against the laws that if you consider yourself to be free from sin, cast the first stone. That was seen within the perspective of the Jews as Jesus rising up against the governors, considering himself as a law. Now, before Pontius Pilate, when the going got tough and they realized that they were not able to convince Pontius on the count of treason, they also mention the count of sedition. In Luke chapter 23, verse 5. When we say sedition, it literally means you are inciting people against the government. When you read it carefully, the Bible stated that they told Pontius that this man, he has been stirring up people against your government in Judea. He actually started from Galilee. Actually, that statement helped Pontius Pilate to an extent, because when he heard Galilee, he asked, is he a Galilean? If he has taken to Herod, because the man was sweating. But that statement only meant that this man is championing people against the policies of your government. The difference between sedition and treason is, for treason, you seek to overthrow the government. But for sedition, you seek to counter the policies of government, or you seek to make the government unpopular. So even though you don't want to be the president, but whenever the government makes a decision, you incite people against that decision, making the life of the government difficult. So note that before the various courts, Jesus had to face a count of blasphemy. That's before the Jewish law, a count of treason, and a count of sedition. Now, the next thing we have to deal with is when we say the trial of Jesus Christ, what went into the trial of Jesus Christ? From an analysis of the Gospels, Jesus Christ was tried before 4 different panels. So what I will say as a caveat here is the analysis I made is from a content analysis. Actually, we have some theologians arguing that some of the accounts are wrong. I don't want to delve into that. From the analysis of the 4 Gospels, there were basically 4 different trials we have to analyze. When you read the books of John, you notice that John says Jesus was sent to the house of a high priest called Annas. Now, when you read Luke and Matthew, you notice from Luke and Matthew that Jesus was sent before the Sanhedrin. Even one of them says sent before the Sanhedrin at the night. The other says in the morning. So if you want to even combine both without canceling one from the other, you say Jesus went before the Sanhedrin twice. Maybe because per the Jewish laws, if there's a majority decision, they have to reconvene. So it is possible he was sent to the Sanhedrin twice. The third point, Pontius Pilate. When you read Luke, Matthew, John, we learn of Jesus being sent to Pontius Pilate on a charge of treason and sedition. And 4, when you read Luke, we learn that when Pontius got the opportunity and they mentioned Galilee, he said, the Galilee champion is in town, Herod. Please take him there. So now to the body of our discussion. If we want to ask ourselves whether or not natural justice was upheld during the trial of Jesus Christ, we have to take all these 4. We analyze all these 4 to determine whether the side of Jesus was reasonably heard and whether there was any of these panels. Was Annas biased? Was Pontius biased? Was Herod biased? Before we come to the tail end, whether or not Annas, Pontius, Sanhedrin, or Herod can rely on any of the 4 exceptions to establish the legality of the trial. Let's look at the first one, Annas. So our discussion will be centered on the 2, that is Odi authoring pattern and Nemo Eudes. Now let's look at Odi authoring pattern. When you read the Bible carefully, you realize that Annas did not put any charge before Jesus. He was basically questioning Jesus. What you could deduce from that was that Annas was soliciting for charges which will be proffered against Jesus. So if a judge fails to tell the accused what you have done, for the accused to defend himself. Remember that we stated that merely hearing somebody speak does not mean you have heard a side. The circumstance must be reasonable enough to establish that natural justice has been upheld. When you look at this holistically, you realize that the side of Jesus was not actually heard. Because what Annas was doing was a fishing expedition. He wanted evidence against Jesus Christ. Now, remember, we stated that if we want to hear the side of anybody, the circumstance must not be a hostile circumstance. It must be accommodating. When you read the Bible carefully, you will notice that in the course of the questioning, Jesus took some slaps. So even assuming charges were laid before Jesus Christ, for Jesus to answer, the fact that the situation was within that or was a hostile situation, we can argue that the side of Jesus was not heard. When you read the Bible, you realize Jesus gave answers. What you need to note is that giving answers is not sufficient. But the question is, was the person given a reasonable opportunity to be heard? Now, as evidence of that, we will have to look at the conversation between Jesus and Annas from John 18, 19 to 23. Add.
John 18, 19 to 23. 19. The high priest questioned Jesus about his disciples and about his teachings. 20. Jesus answered, I have always spoken publicly to everyone. All my teachings was done in the synagogues and in the temple, where all the people come together. I have never said anything in secret. 21. Why then do you question me? Question the people who heard me. Ask them what I told them. They know what I said. 22. When Jesus said this, one of the guards there slapped him and said, How dare you talk like that to the high priest? 23. Jesus answered him, If I have said anything wrong, tell everyone here what it was. But if I was right in what I have said, why do you hate me?
Yes. So from this statement, actually, one deduction we can make is that Jesus knew his law. Remember from what I'd read, Jesus said, question the people who heard me. I have told you previously that for surrendering, a person cannot be convicted on his confession. You need evidence. So Jesus was trying to tell him that I know your law. Your law says if I've committed any crime, you need two or more consistent witnesses. Why are you then questioning me? But even if we can consider a charge to have been properly laid before Jesus, there was a slap. The situation was so hostile that you cannot consider the side of Jesus to have been effectively taken. So it means the first part of natural justice, or the authoring pattern, was non-existent before Annas. Now let's look at the second part of natural justice, nemo judice. That is, a judge should not be biased. The first thing you have to note is that the chief protagonist for the arrest of Jesus and the trial of Jesus was called Caiaphas. Now, Caiaphas' in-law was Annas. Caiaphas was actually the chief priest as at then, and Annas was a retired chief priest. So it is basically an in-law affair. If you look at the approach Annas used, you could realize that Annas was trying to assemble evidence for somebody. You could notice that Annas was trying to assemble evidence for somebody. And that person may be Caiaphas, because from the Bible is clear that Annas had a relationship with Caiaphas. They were in-laws. Secondly, assuming the fact that, remember I stated we can all be friends. Being in-laws is just trivial. Look at the methodology Annas used. You could deduce that this man has already taken a position. You are questioning somebody about his doctrine and his teaching. Not that you are questioning somebody to have committed a crime, but about his doctrine. You could establish that he had an interest. He sought to protect the viewpoint of the Sanhedrin. And the last point you need to note is that Annas was a Pharisee. And the evidence shows that it was the Pharisees who bribed Judas Iscariot. When you read deep into the books, you realize before Jesus was even sentenced to death, Judas returned the funds to them and they threw it on the floor that they cannot take blood money. So on these three accounts, you may say that before Annas, there may have been some form of justice, but the justice was not quality enough to meet the standards of natural justice. At John 18:12, which talks about the relationship between Caiaphas and Annas.
John 18:12. Then the Roman soldiers with their commanding officer and the Jewish guard arrested Jesus, tied him up, 13, and took him first to Annas. He was the father-in-law of Caiaphas, who was high priest that year. 14. It was Caiaphas who had advised the Jewish authorities that it was better that one man should die for all the people.
Thank you. So Caiaphas was actually establishing a prophecy. We stated that it's better for one man to die for all the people. But the Bible was clear that the man Annas was related to a man called Caiaphas. And Caiaphas had openly stated when they were discussing the influence of Jesus after raising Lazarus from the dead, and they feared that the Romans would take their power from them. The man said that it's better for one man to die for all of us. So please note from the perspective of Annas that no, there was no natural justice. Now we move to the Sanhedrin. We have to ask ourselves whether the Sanhedrin upheld the doctrine of natural justice. We will start from Odi Authorum Partem. For Odi Authorum Partem, the first thing you have to note is that before the Sanhedrin, there was no proper charge laid before Jesus. I have previously informed you that per their rules, they needed a charge and two consistent testimonies. When you read the books, you realize they were basically asking Jesus, were you the person who said this? The only consistent testimonies they had was two men rising up to say, we heard him say he will build the temple in 3 days. I think in the slides, I wrote 2 days. It's supposed to be 3 days. Build the temple in 3 days. Now, I told you there are procedural rules that they needed 2 men. It is for that reason that the Bible specifically quotes that there were 2 men who said, we saw that. He said that. In some of the books, he says some men, but in other versions, he says 2 men. And when you also read the statement, you notice, or the books, that Jesus was convicted on his own statement or confession. I have told you previously that per their terms, you cannot be convicted on a confession statement. You needed direct evidence to establish guilt if the offense is punishable by death. And on the 4th note, there was trial by ordeal and concealment. Indeed, when you read some of the books, you realize that the trial was done in a very concealed situation because they were afraid the people will rise up against them. The people had praised Jesus. Women laid down their cloth on the floor for Jesus on a donkey to pass by. They were afraid. So they had to go through a trial in a form of concealment. Now, what do we learn from this for Odi Authorum Partem? What we learn from this is even if Jesus made a statement, his side was not efficiently heard. Remember, I told you that the principle is not that a person must be heard, but there must be the situation of reasonability. The situation must be that of reasonability, that you must give the person the opportunity to be heard, a reasonable opportunity to be heard. That trial flouted all their rules. The fact that they cannot have in-camera sitting, the fact that they needed 2 consistent testimonies, The fact that you cannot convict a person on his confession. And for that matter, we can say that the principles of all the authoring pattern were not upheld. Add the reading from Matthew 26:59.
Matthew 26:59. The chief priests and the whole council tried to find some false evidence against Jesus to put him to death. 60. But they could not find any, even though many people came forward and told lies about him. Luke 22:71. And they said, "Don't need any witness. We ourselves have heard what he said." Mark 14:57-59. Then some men stood up and told just lie against Jesus. 58. We heard him say, "I will tear down the temple which men have made, and after 3 days I will build one that is not made by man." 59. Not even they, however, could make their stories agree. Mark 14:65. Some of them began to spit on Jesus, and they blindfolded him and hit him. "Guess who hit you?" they said, and the guards took him and slapped him.
Yes. So you notice from all this that there was actually no credible evidence within the procedural rules of the Jews. In addition to that, there was evidence of spitting and slapping. Of course, within the light of soliciting for evidence. And if you remember Luke 22:71, they even accepted that we do not need any witnesses, basically against their own rules of engagement. Now let's ask ourselves whether the Sanhedrin were biased. For the Sanhedrin, in terms of being biased, it is patent on the face of it. But we need to assess the level of they being biased. All that will add up for you to know that Jesus, within their heads, was classified as a zealot. And within their head, they sought to protect some form of authority they yielded. The first point we can establish against them for the purpose of establishing biasness was bribing Judas Iscariot to facilitate an arrest. It was clear that they had an interest in the matter. But the question you ask yourself is, what were the interests in contention? What were the interests in contention? Note that there were three main interests. The first was spiritual relevance. Remember the story of Lazarus. Imagine that you being praised in a city as high priest. Somebody is dead. It was all over the town that somebody is dead. High priest, I'm sure, was informed, and high priest stated, when it gets to the time of the funeral, call me. Then a certain young man goes to the place to rise the person from death. He did not only do it on the day that person died, though. He waited for some time for you to, so that nobody can argue that medically he was asleep. He wanted you to know that he is dead. Nobody has been able to do this. I have done so because I've been sent by God. They feared that their relevance as a spiritual entity was dwindling, and the continuous existence of Jesus threatened them. The second is economic interest. Whatever happened at the temple, that is people trading at the temple, it was not a one-off event. Indeed, that temple was called Herod's temple, or the second temple. From history, that temple was, the first temple was the temple built by Solomon. So it was basically a reconstruction of that temple. It is called Herod's temple because even though it was a temple of God, they had to solicit for help from the Romans to build a temple. When you read the history behind that, you realize that there were even some conditionalities the Romans gave, that even though we are building a temple, we can use it for other activities which are not spiritual activities. Those were the activities Jesus was referring to. And ask yourself, who were the people trading at the temple? Or who were their masters? Remember the Sadducees, the big men in the society. They have realized that you, within the Sanhedrin, the spiritual people are suffering. You have also brought your game to our doorstep. You want to destroy our businesses too. The temple within the context of the Jews was revered. They go there to pray. That was where, if you are looking at it from an economic perspective, that was the rare spot for business. And you want to destroy that too. There was also political relevance. Aside you making people think we are powerless, you affecting our economic interest, they also feared for their political power. Indeed, after Jesus had rose Lazarus from the death, when you read the books on the conversation by the Sanhedrin, they even feared that the Romans would take their powers from them. Remember, from the beginning, I told you that there were two existing systems, just that the Jews were allowed to practice or to engage in their practices subject to the Roman ordination. So they fear that this small opportunity we are getting as leaders too, you want to take that political power from us. The next point where you have to also realize that there was actually a level of biasness was the level of hostility shown by the Sanhedrin. Indeed, when you read the books, you realize after Jesus had made a statement from which they inferred blasphemy, the high priest tore his dress. You don't need evidence to show a judge has an interest in a matter. When he tears his dress, I'm sure the gesture was to tell Jesus that today you are dead. We all know how you tear your dress in the light of anger. When he tore his dress, imagine you seated in court. Your case is being done. And you make a statement as a witness, and the judge tears his dress. You need nobody to communicate to you that this judge has an interest in the matter. And the last point you like to make here is a unanimous decision. When you read the books, it says that, and they all agreed. Of course, there are debates at one breath whether they were all in agreement, because some people argue that Joseph of Arimathea did not agree. But let's look at it from the gospel. The Bible says, and they all agreed. A unanimous decision, we have already stated that when there's a unanimous decision, we raise eyebrows, because it is not as if the Sanhedrin, they were actually assembled from one family. Jesus belonged to a sect. Definitely, there should have been a representative there. You forget about representative. This was the same man who fed people with loaves of bread. This was the same man who healed people from their sight. Even if none of the people in the Sanhedrin was part of the healing, maybe they may have been related to any of them. So if the charge was that of his teaching and the way he practiced within their heads, the way he practiced Jewish customs, then they shouldn't have reached a unanimous decision. It only creates a picture that a group of men ganged up against him, of course, in the light of prophecy. So that is for the Sanhedrin. Now let's look at it from our man Pontius Pilate, who in most accounts or descriptions is argued to be a fair person. Please note that from the context of natural justice, Pontius Pilate can also be brought to the table for slaughtering. Let's look at Odi Authorum Partem. From Odi Authorum Partem, that is whether Pontius Pilate had the side of Jesus. When you read the engagement between Pontius and Jesus, you realize that Pontius tried his best to give Jesus a reasonable climate. There was no form of hostility from Pontius. Inasmuch as he was considered as an autocratic leader, from that you could determine that he was trying his best to extract the truth. But from the perspective of Odi Authorum Partem, we may question Pontius from two angles. One, from the word go, there was no proper charge laid before Pontius for the trial of Jesus. Indeed, the leaders who brought Jesus to Pontius affirmed that there's no charge before him. Secondly, the leaders told Pontius point blank that we have brought this man before you to regularize our decision. Now, why would they bring Jesus before Pontius to regularize their decision? Because of, in quotes, the colonization. So the power to put people to death was truncated by the Roman government. So in as much as they were given some forms of power, the Roman government decided to take that power to put people to death from them. Just like if you know the history of Ghana legal system, you note that when the British came to our land, they decided to take criminal jurisdiction from our chiefs and they left them some form of civil jurisdiction. Yes, it's the same way. To exert their control, they decided to take away that power from them. So the reason why they sent Jesus to Pontius, the Sanhedrin sent Jesus to Pontius, was to regularize whatever decision they have taken. So the point is, if Pontius actually decided to appraise all the author pattern, then what we are trying to say is Pontius should not even have heard Jesus in the first place, because there need to be a charge for the person to answer to the charge. There was no charge at all. They were basically stories being told by them. Add John 18:29 to 31.
John 18:29 to 31. 29. So Pilate went outside to them and asked, "What do you accuse this man of?" 30. Their answer was, "We would not have brought him to you if he had not committed a crime." 31. Pilate said to them, "Then you yourself take him and try him according to your own law." They replied, "We are not allowed to put anyone to death."
Thank you. So you notice that from the word go, you bring the man before the Roman judge. He steps out to ask you, what has he done? And you are telling him that if he hasn't done anything, why would we bring him to you? There was no proper charge. When you continue reading the books, you will notice that at a point, the books say that Pilate realized that they were jealous of Jesus. Because from what they were saying, you could deduce that they are saying, this man, you heal somebody from the dead. You go for a donkey, you enter Jerusalem, women are praising you. And of course, because they are Jewish leaders, they know the story between David. When David killed Goliath, David has killed 10,000 men. They know those stories. So they were wondering, especially when the women were calling Jesus basically a David reincarnate, King David. So I'm sure Pilate realized that no, there was no charge. But at the end of the day, Pontius still proceeded to examine. One thing you should note is that they were under colonization. So under the proper course of things, Pontius had the power to tell them, go away. You guys are making no point. But of course, there will come to the exceptions, which includes the prophecy, which had to be established. Now let's look at it from the angle whether or not Pontius was biased. It is argued by most people that Pontius was a fair judge. In my opinion, Pontius was not a fair judge. To me, Pontius actually acted as a biased judge. Remember that I told you that in terms of being biased, it is not necessarily biased towards material things. It can be biased towards your own personal conflict or your own personal interest, your relationship interest, or a political interest. Now, if you have a Ghanaian judge, like I gave the example, who is a vegetarian, he has continuously said outside that if he sees somebody chewing meat, he'll slap the person. Then you are put before this judge on a charge of having killed a dog. I'm sure he will not spare you. It is the same analogy here. Pontius Pilate, from the word go, affirmed Jesus is innocent. If you affirm a man is innocent, what is the next thing you have to do? Discharge the man. But after affirming the innocence of Jesus, he crowned Jesus. He put a crown on the head of Jesus. Was it to incite the people? 2, if you affirm Jesus was innocent, you stated that per your customs, at the end, you have an opportunity to free one prisoner. The word Pilate used was one prisoner, not one suspect or one innocent one. Why will you then put Jesus and Barabbas there for them to choose? Because, of course, if he's innocent, then he's not a prisoner. The answer is simple. During the interactions with Pontius, the people told Pontius that you know that there's a certain man called Caesar. If you do not do our bidding, we will tell Caesar that you are not his friend, you are a rebel. And as I mentioned, if you know how Caesar became Caesar, or if you have read the literature, Julius Caesar, you understand why Pontius in the Bible said immediately Pontius heard that, he sat down on the Gabbatha, because he realized that this statement you have made is one, I don't want to go out. I don't want Caesar hearing, because at that time, Caesar has actually been likened to a god. Because those days, to become Caesar, you have to fight. Those days, to become Caesar, you have to engage in a fight. And this man has been able to defeat people. Pontius will be, I'm sure he was considering, hey, looking at the way he defeated those people, me, Pontius self, where do I stand? So note that it is not really the case from the perspective of natural justice that Pontius is entirely clean, because he had a conflicting interest. The first is political power, because from his angle, am I losing my seat? Am I losing this opportunity Caesar has been given to me already? These people are saying I am an autocratic leader. Secondly, I'm sure when he heard that statement, he was not thinking about only himself. He thought of his family, especially when his wife sent a message to him that I've had a dream. Do not get yourself involved. I'm sure one thing he thought of is when Caesar catches me, he will finish me and my family. He thought of his person, not only politics. What happens to me if this thing gets to Caesar? Will I be prosecuted with Jesus that I am in support of what Jesus is doing? From the perspective of natural justice, Pontius also did not appraise natural justice. He did not give Jesus a reasonable opportunity to be heard, because there was nothing to be heard on. Secondly, he had an interest other than that of justice. Why then will you free a man and afterwards you put the man, you tell the people have to free one prisoner, then you include the man you claim to be innocent as within the bracket of prisoners? Add John 19:12-13 and Matthew 27:15.
John 19:12-13. 12-13. 12. When Pilate heard this, he tried to find a way to set Jesus free, but the crowd shouted back, "If you set him free, that means that you are not the emperor's friend. Anyone who claims to be a king is a rebel against the emperor." 13. When Pilate heard these words, he took Jesus outside and sat down on the judge's seat in the place called the stone pavement. In Hebrew, the name is Gabbatha. Matthew 27:15. At every Passover festival, the Roman governor was in the habit of setting free any one prisoner the crowd asked for. 16. At that time, there was a well-known prisoner named Jesus Barabbas. 17. So when the crowd gathered, Pilate asked them, "Which one do you want me to set free for you? Jesus Barabbas or Jesus called the Messiah?" 18. He knew very well that the Jewish authorities had handed Jesus over to him because they were jealous.
Thank you very much. So you will notice that the position of Pontius is very, very, very questionable. You said this man is innocent. Now, the next thing you are saying is, according to our custom, I'm freeing one prisoner. It only establishes that that statement made, we are going to the emperor, drew him into a position of conflict. He was thinking of his political power, thinking of his life, and thinking of his family. Now he moves to the man Herod. From the books, you realize that when Pontius was sweating, they gave him an opportunity when they were making a charge of sedition, that he started this thing from Galilee. And Pontius, I'm sure it quickly triggered Galilee. I heard the Galilee champion is in town. Take him to Galilee. I don't have jurisdiction over this matter. We have to ask whether Herod heard the side of Jesus. The first thing you have to note from the Herod perspective is that the situation was very hostile. When you read the books, you realize that Herod was basically making fun of Jesus. He did not even give him the opportunity to speak out. He was actually enjoying himself. Secondly, Herod concentrated on red herrings. Jesus was brought before you on a charge of treason. And Herod was asking for miracles, asking Jesus, are you the king of the Jews? Basically, from the Herod perspective, you could tell clearly that the side of Jesus was not heard. He was too much interested in the miracles he actually had dreamt of seeing Jesus performing. That I'm sure when they brought Jesus, it was like, Unye. Only that from the prophetic point of view, this transfer of Jesus from Herod to Pontius united them. They were actually not good friends. But in terms of natural justice, you could say that clearly Herod did not give Jesus the reasonable opportunity to be heard. John 18:29-31 add.
John 18:29-31, 29. So Pilate went outside to them and asked, what do you accuse this man of? 30. Their answer was, we would not have brought him to you if he had not committed a crime. 31. Pilate said to them, then you yourself take him and try him according to your own law. They replied, we are not allowed to put anyone to death.
Thank you. So the essence of this is for you to know that from even the point of transfer of Jesus from Pilate to Herod, there was no need for that. Perhaps that is the reason why when the matter got to Herod, he was so interested in seeing miracles performed. Because being a wise man, he realized that, there's no need for this, because the first trial you had, there was no charge preferred against the man. Even though when you read the books, you realize they were trying their best to pin Jesus down before Herod. At the end of the day, he said, send him back to the person who sent you. Because he didn't actually, so you could determine that he didn't want to get himself involved. Now, from the perspective of biasness, note that Herod's story is very peculiar. People will ask, why did Herod play those games or play along those lines? There's basically a political reason. From the statement Pontius made when Jesus was sent back to Herod, Pontius said that, you see, I said he's innocent. Herod said he's innocent. So it is clear that Herod did not establish the guilt of Jesus. But Herod had several interests playing at that point. One was a personal interest. The gentleman wanted to see a miracle being performed. I'm sure from his palace, he has heard too much that he wanted to see water being turned into wine. So he saw that as an opportunity to see one of those. Secondly, Herod was actually, the name Herod was actually important in the death of John the Baptist. And from the books, you realize that there was tension brewing This prophet, who is actually an innocent prophet, baptizing people and preaching to us about the coming of a heavenly kingdom, you have killed him. Now, the next man who has come in, who is an action man, he is doing the miracles and everything. You want to also be involved in his death. Politically, Herod will decide to abstain from it. Secondly, Herod also feared one thing, that Jesus was actually John the Baptist, that John has resurrected from the dead. Perhaps after he has heard the story of Lazarus coming, and remember also that during those times, the prophecies were in their palms. He knew that the Savior, there's a prophecy that the Savior will rise in 3 days. So perhaps he was thinking, is this John the Baptist? Will it be good for me to interfere in all this? So in terms of the game Herod played, it was simple. He did not have an interest of justice. If he had, he would have accepted that, yes, he has been brought before me as a Galilee man, but he is not actually guilty. Take him home. Of course, from the perspective or from the root of Jesus, you realize it is questionable whether he's even, or he can even be considered as a man from Galilee. But let's put that aside. The whole point is, if he's innocent, Herod, Pontius, free the man. From Herod's perspective, Pontius' own was political. He was afraid. Herod also has some form of fear because he was thinking, is this John the Baptist? And the reading.
Luke 23, 9 to 11. 9. So Herod asked Jesus many questions, but Jesus made no answer. 10. The chief priest and the teachers of the law stepped forward and made strong allegations against Jesus. 11. Herod and his soldiers made fun of Jesus and treated him with contempt. Then they put a fine robe on him and sent him back to Pilate. Luke 23, 8. 8. Herod was very pleased when he saw Jesus because he had heard about him and had been wanting to see him for a long time. He was hoping to see Jesus perform some miracle. Matthew 14, 1 to 2. At that time, Herod the Tetrarch heard the report about Jesus. 2. And he said to his attendants, "This is John the Baptist. He has risen from the dead. That is why miraculous powers are at work in him."
Thank you. Do you realize that Herod already, he has made a statement to his attendants that from these stories you guys are saying, I think it is John the Baptist. Now they bring the person before him. He was so pleased that I want to see a miracle. Luke 23, 9 to 11 even says they were making strong accusations against Jesus. And all what Herod could do was to make fun of Jesus. He was not interested in getting himself involved. So from that perspective, you could deduce that even though he clearly affirmed through his conduct that Jesus was innocent, he also had an interest other than that of obtaining justice. But the question we will ask ourselves here is, in spite of all these breaches, what are the possible defenses Annas can rely on, the Sanhedrin can rely on, Pontius Pilate can rely on, and Herod can rely on to establish the legality of the death? Remember, we stated that there are 3 key exceptions to a charge of natural justice. 3 key exceptions. The first exception is waiver of right. Waiver of right literally means that you were supposed to speak out, you failed to do so. We can argue that Jesus was quiet, of course, because whatever was happening was in line with his own prophecy, the prophecy of Isaiah and the prophecy of Jeremiah. Indeed, even on the cross, he stated that but for the fact that I want your will to prevail, let this cup pass me by. He accepted that is what I have to go through. So from the perspective of all these breaches, they can say that This man, he never at a point stated that he's being abused, and that is not within the tenets of Jewish prosecution procedures. 2, necessity. There was no alternative structure. From the biblical perspective, there was the Sanhedrin. There was no substitute for the Sanhedrin, meaning no matter what, even if the Sanhedrin was biased, they had to engage in the trial. There was Pontius Pilate. He was in charge of Judea. There was no substitute. There was Herod. He was in charge of Galilee. There was no substitute. So, assuming even Jesus has complained, nothing could have been done because there was no substitute. In relation to legal authority, remember we stated that the third exception is legal authority. When a law says Mr. A should discharge a duty and no one else, it means if you bypass Mr. A, you have acted illegally. For legal authority, it is clear that whatever the Sanhedrin did in terms of the composition of the Sanhedrin, they were in compliance with the law. Whoever Pontius was in compliance with Roman law. He has been appointed. Whoever Herod was in compliance with the law. Even Herod was from a monarchical system. For that, there's no substitute. So, from the perspective of all these three, you could say that the trial, from the perspective of the law, was legal. But the whole point is the basis of the legality was the waiver of right. And the basis of the waiver of right is all had to happen because of the prophecies. Because when you notice from the point even of procedural rules, you realize that from the first point, they flouted all the procedural rules. The first point they flouted the procedural rules was that a person should be tried before the Sanhedrin. Why was he then sent to Annas, assuming whatever happened before Annas was a trial? Down to Herod. The point involving Herod was that there was no charge. The people had openly stated that if he has not done any crime, why is he here? Why did Pontius send him there? So all this falls within the line of the biblical perspective that they were all supposed to establish prophecies. But we need not know all this without taking something home. The first question we'll ask ourselves is, what are the lessons we can deduce from this? Because there's only one savior we have, unless there's another prophecy of a savior coming. But as we are here now, if you believe within the lines of the gospel, there's only one savior. Meaning, if tomorrow you are engaging in any trial, do not assume the position of Sanhedrin. There's no prophecy. You have to uphold natural justice. If you're in your house making a decision, do not assume the position of Herod. There's no prophecy. You can't say you have sacked your worker because there's a prophecy. Whatever happened with Jesus fell within the lines of the exceptions. But in as much as we are learning from this from a religious sense, we have to also learn from this from our day-to-day life. The first thing we have to learn is that natural justice, it cuts across board. It starts from self-condemnation. The point that you are in your room thinking that this examination I wrote, it didn't go well. The point you are in your room thinking that this business I engaged in, it didn't go well. And you want to condemn yourself, that is some form of trial. Ask yourself, am I being biased towards a negative? Ask yourself, have I given myself the opportunity to be heard? Because maybe if you take a pen and paper to go through an analysis of how you handle that business, you realize that you don't have to condemn yourself. Secondly, when you are dealing with people, you have to also note that whatever you engage in affects them. You need not be biased. You always have to allow people the reasonable opportunity to be heard. You don't call your worker to the room and say, if you don't give me a correct answer, I'll slap you. You will hear what you want to hear. You will indeed hear what you want to hear. the person will give you an answer which you want to hear. The second point is natural justice must be intentional. Don't be at your workplace and you think of yourself as Solomon. So I am a wise person and I make all decisions. Take a pen and paper and draft something to govern your work. Don't be in the house and think you are always right. You have a diary, write how you deal with matters in the house. It may help you, because we have learned today that there's a possibility of you flouting rules from the beginning to the end, which may lead to the death of another person. Secondly, note that there's no permanent immunity against natural justice. Don't sit anywhere and say, me, I am a president, so there's no way I'll be prosecuted. Indeed, everybody has his own master or mistress. Tomorrow may be your turn. So you see the comment there, even Jesus Christ. What that means is that if you are in an office, from today, you need to assemble your people down and tell them, let's draft something, because today it may be somebody, tomorrow it may be you. 3, natural justice requires investment. Investment means as the time progresses, whatever you put down must meet the ends of time. That is the reason why we had to study into the political structure of the days of Jesus. Now we have courts. Now we won't have our chieftaincy tribunals, assuming we are even comparing the Sanhedrin to the chieftaincy tribunal, exercising criminal jurisdiction. It means tomorrow, like what happened in the COVID time, we will be working virtually. So at any point of change, you have to also make sure your standards of natural justice meet the ends of time. 3, justice must be satisfactory justice. When we say justice must be satisfactory justice, even if you say a person has been sentenced to death, the person should smile and say, I deserved it. The statement we always make that the book say 5 years, he's going down for 5 years, sometimes, and do not establish effective justice. Let's go down, let's deconstruct the procedure you use for sentencing, for conviction. The procedure you use to sack that worker, is it because the person was in a dreadlocks? From that point, you decided that, hey, dreadlocks, it means it is 1 hour. Is it because the person you are about to interview is noted to be very audible? So you as a judge, you have also stated in your head, today I'll show her Ibishia. That mentality means when the person starts expressing himself, you tell the person, you are Mr. Know-all. That statement is effective in dissolving any reasonable climate for a person to communicate. And 3, natural justice deals with communication. If you draft a natural justice structure for your firm, you keep it in a briefcase so that when you have your friends, you show it to your friends, you have done nothing. Briefcase natural justice is no natural justice. It must be practiced. There must be evidence of practice. There must be evidence that whatever you have written, you do, or you put your actions or your words into action. Now, having said so, we cannot go without learning how to draft or how to create a natural justice compliance wheel. For the purpose of creating the compliance wheel, we are putting ourselves in the situation of a small firm. So it may be your family. It may be the circle of your friends. It may be that business you have and your workers are from 1 to 100. It may even be for your own self. The point you stand in front of a mirror to tell yourself that I'm no good. You are a small firm in your own way. So how do we look at addressing this? The first thing we will look at is Oddy, author, and pattern. When you look at the screen, you realize there are 4 subdivisions if you want to create a wheel for your office. The first subdivision is there must be clearly defined behavioral standards backed by effective communication. You need to let your workers know that in our office, you can engage in A and you cannot engage in B. It is usually contained in a code of ethics. So for the purpose of our drafting, I created a scene or an image of a small firm, and we are looking at a firm prescribing as their code of ethics a time within which, or a time before which you cannot depart from work. So it is stated, assuming our firm states as our code of ethics that it is not permitted to leave the workplace before 4 p.m. That is a defined code of ethics. You need to have one. It shouldn't be the case that you tell people that this thing you did, my soul doesn't like it at all, especially those with shops. You tell your workers, my soul doesn't like it at all. That is no natural justice. They must know what they are actually engaging in. Secondly, when you are adopting a structure, you need a method which reasonably notifies defaulters. It should not be the case that you wake up in the morning, go to your workplace, you call one of your workers, and you inform your worker that I saw you in my dream. You were chasing me. That's a different situation. Or I learned last week that you have been stealing from me. Before there can be adjudication, there should be a method of notification. That method should have 4 elements. 1, it should state the charge and the repercussion. What are the attitudinal standards expected, and what are the effects of breaching them? 2, the notification document should contain sufficient information and time. You do not tell somebody that 5 you are to attend a sitting for a missing 5 cedis. You need to give information that because we have a CCTV footage of you entering the office at 8 p.m. The person a clear path for defense. 3, you should provide for a clear method for answering the charge. You do not tell somebody that my money is missing, and I told myself that anybody who visits the fridge the earliest in the morning is considered to have stolen my money. That is not a clear method for answering the charge. If you want your workers to answer to a charge in the form of a writing, you need to do so. You need to state so. If it is at a disciplinary sitting, you need to state so. 3, you need to be clear on the concept of waiver. Perhaps there are a lot of people in prison now because they didn't know that they could cry foul when the judge acted in a biased manner. Some people actually feel like when I speak out, the judge will be infuriated. So I'll actually be jailed for a longer term. You need to clearly state that you have to speak out. Your failure to voice out your statements will be considered as a waiver of your right. The third point is that you should be ready to support the defaulter. This is difficult, but if you want to appraise natural justice, then you don't have an option. The person who you is standing trial in criminal terms is called an accused person. That person is being accused of a charge. From the word go, you need not take a judgmental pose. I gave an example. When you are dealing with architects and you are questioning the work of an architect, you need to make provision. You need to make provision for the architect. You need to make provision for the architect to put out a video or put out visualization of his work to justify whatever he has done. You should be ready to support defaulters. And the fourth point is that When you are talking about the authoring pattern, there must be an identifiable structure of adjudication with a supportive climate. The old method of doing things before high school disciplinary committees, that immediately you appear before them, they give you six lashes before interviewing you. It is no natural justice. The climate must be very supportive, including the choice of words. So assuming we are in a small firm and we want to design something, this is how it may read us. Please read the writings on the right side for me.
On the right side, from the top.
Yes, from the top.
It is not permitted to leave the workplace before 4 p.m. We have received a report of you leaving the workplace at 3 p.m. on 5th January 2021. 2. We have attached a copy of the complaint letter and logbook for your perusal. 3. You are hereby invited to a disciplinary sitting in 1 month. 4. Kindly let us know if we can assist you in making a defense in any way. 5. Please take note that you have a right to legal representation, and in the event of your failure to attend the sitting, into brackets, without justification, we shall proceed to make a decision. 6. The sitting shall be held at the conference room of our office in Labadi. 7. We shall make provisions for internet, a projector, and a laptop. Kindly let us know if you require extra logistic support.
Thank you very much. So, from the language of this, even though the person is being sent to the slaughterhouse, you are showing support. You want to give the person a climate, a workable climate for the person to voice out his opinion. And from that, you can actually reach a decision which will have the person smiling. You may sack somebody from work, but the person will smile and say, "That's my boss. He's a just boss." People be hear that every time. It is not the fact that your money is missing that you send the police to give somebody 5 slaps and you question the person at the police station. You have not projected natural justice. Now let's look at it from a nemo iudice standard. Remember, we stated that nemo iudice means when you are seated as an adjudicator, you should show no element of bias. You should show no element of bias. The first thing you have to note is if you want to design an effective structure, the first thing you have to do is you should clearly define broad standards for the appointment of an adjudicator. So you need to state that to be an adjudicator, maybe you should be 70 years old, 40 years old. There should be a defined standard. And in my opinion, there should be no restraint on the numbers for possible adjudicators. I am saying so because assuming there was provision for a substitute for the Sahindrin, maybe somebody might have raised an objection that looking at how you people are behaving, or maybe Pontius would have stated that let's take Jesus back to your substitute for your substitute to make a decision. Whenever there's a fixed number, there's the likelihood of the fixed people forming a team against somebody, especially when the fixed number of people possess some form of political power. 2, there must be clearly defined system of appointment, but that system must be in a way a biased system. When I say the system must be biased system, I mean the system must tilt in the favor of the defaulter. So even though he's a person standing the trial, if you are appointing judges, you should favor him. If possible, he should have a say. But that means that the system for appointment of judges must be a blind process. It should not be the case that you have a company, somebody saying, "I'm part of the disciplinary committee. If you like, don't work like Jesus." Like people say. It should be a blind process. Remember, I stated that there should be no limit on the numbers. It's dangerous. So if there's any case, blind process means you may decide to write all names in a paper, fold the paper, and you handpick the people who handle the adjudication. Because you are dealing with natural justice and there's waiver of rights, you should tell the defaulter that you have the right to object to any appointment. And that right is not limited from only the beginning of the process. Any time of the process, you can raise an objection. We are saying so because from the beginning, you may not know until maybe you are driving home. Then you see the judge and the other party, the complainant, seated at a fufu joint, eating fufu, especially when they have bottles in their hands and you see them doing cheers. I'm sure you may even crash your car by a tree. So it means the process for raising an objection of foul should be continuous even to the point of judgment. Again, because you want to eliminate any form of timidity, there should be a clear statement that the person has a right to object, and the person will be considered to have waived his right if that person fails to object. And the last point is, remember what I stated, always have substitutes, because that defense we have for natural justice necessity, in my opinion, should not be so. If the law says Kofi should appoint a judge, the law should provide that in the event of Kofi being biased, Amma should do the appointment. At least there should be a substitute, because we know the popular saying that power corrupts and absolute power corrupts absolutely. Meaning, if you do not provide substitutes, you are just giving people the power to be biased. And the last point, which I pray that we all take home, is when a person is appointed as a judge. When a person is appointed as a judge, that person should sign to a document. That person should sign to a document affirming his independence. Not only signing, the person should provide collateral. I'm saying so because from the story of Jesus, you realize that it led to death. In another office, it may not lead to physical death, but it may be somebody being sacked from work and the person cannot pay school fees for his children. The person may grieve, there may be a sick partner, and the person may not make provision. In any case of breach of natural justice, there's some form of death, meaning the person seated as an adjudicator should be made to sign. And the person should be made to provide collateral that in the event I exhibit signs of being biased, that money should be taken from me. That will force people to speak out from the beginning of the trial that this matter, I don't think I can handle it because I know the person and I can't go against his bidding. If you are designing all this into a will, it should read like this. Add from right side from point 8.
Any person above the rank of junior manager can be appointed as an umpire. The adjudicator shall be appointed through balloting from an opaque box. An appointed adjudicator shall be asked to confirm his independence at the time of appointment. 10. The accused shall have the right to object on reasonable grounds to any appointment. 11. The right to raise an objection is not restricted to the commencement stage, but the accused can raise an objection at any point of the trial where there is reasonable suspicion of bias. 12. In the event of failure to object, all decisions taken shall be considered to be valid and effective. 13. Before the commencement of proceedings, the adjudicator shall be made to sign to a declaration of independence, and each adjudicator shall provide collateral to the value of $500 as security for his or her promise. 14. At every point in time, there should be enlisted 20 persons from which 3 shall serve as adjudicators over disciplinary pleadings. Over disciplinary proceedings.
Yeah, thank you very much. So please, this is how you can draft a very small natural justice structure for your firm. In terms of hearing both sides, remember it includes hearing both sides. I've explained to you, supports the person in breach to state a story. Now, in terms of being biased, put a responsibility on the shoulder of the person in breach to raise an objection, and also the adjudicator to state his independence and back it with security. Because somebody may be biased, the person will not speak out until the person has $500 to lose before the person will speak out. Now, my final comments is the biggest lesson we can learn from the story of Jesus, which is one of the biggest lessons, is in all our engagement, we have to try and project true and substantive natural justice. I'm very grateful for your attention. Please, any questions and contributions? Yes, Lefio.
Hello, Nana.
Yes,
Good evening.
good evening.
Actually, I agree with everything you've said.
Okay.
And I'm appreciative for that. The only thing I seem to disagree with you is the conclusion you made that the trial of Jesus Christ was legal, but you have problem with the procedural matters that was involved. To my mind, if you say it's legal, then they would also argue that no one has vested rights in procedural and evidential matters. And therefore, for the procedure and
Lefio, your network has dropped. Okay, so I think I got Levio's question. So Levio's question is based on the rule, the law rule that no one has a vested right in procedure. Which Levio is on? Levio, there's an exception to that rule, that natural justice is so crucial that it is an exception to that rule. So speaking from the strict legal sense, remember when you were treating Order 81, which deals with procedural law, it stated that when a person breaches a procedure, it is not so fundamental unless it goes into natural justice. So even though no one has a vested right in procedure, natural justice is always an exception. It is very fundamental to every trial. Please, any other question?
hello, Nana. Oh, my network. I got
Yes, I got your question. Your
Oh.
question was, the rule is that no one has a vested right in procedure, so we cannot cry foul. Not so.
Yes.
Yes. The exception to that rule is natural justice. Remember Order 81. There are three exceptions to procedure: natural justice, breach of statute, and jurisdiction. Yes. So that is why we are discussing natural justice. So even though you don't have a vested right in procedure, when it comes to natural justice, you can't invoke that rule because it is very fundamental. Please do get it.
Okay. All right, thank you.
You're welcome. Okay. So please, any other question? Okay.
Yeah, hello, Nana.
Yes, my friend Desire.
Oh, Nana, good evening.
Good evening.
About the natural justice, so the person should be given ample time to defend himself.
Yes.
And you made mention of reasonability. So I would like to find out what constitutes the reasonability.
Okay, so for reasonability, we have to determine the situation. Of course, if the matter is very pressing, then the time you allot to the person will not be that extensive as compared to a matter which is not so pressing. So assuming the matter deals with life and death, then of course, a reasonable man may say that informing somebody 30 minutes to the trial will be sufficient. But if it is a matter which does not involve life and death, giving somebody a 1 month period to prepare for a trial will make no difference. Of course, assuming you're an employer, you can put a person on suspension because maybe you're afraid that your company will be collapsed. But it depends on the situation at hand. Desire, please, you get it.
Yes, sir. I have a follow up.
Okay.
Yeah, as you mentioned, an employer.
Yes.
Assuming there is an issue in my office,
Yes.
and let's say I am the key person in that position.
Yes.
My employer did not hear from me, and
Okay.
I was written to proceed. I was written to have been interdicted.
Okay.
In that case, even though auditors have done their work, they've not given me the chance to present my response to the audit queries, and they're investigating, they've not called me. Can I say that they have breached the natural justice rule because they've not heard from me?
Yes, and you can actually sue them under our employment laws. You can actually
Okay.
sue them for a declaration, but only that remember that nobody can force an employer to keep him in his employment. So if you are suing, you are suing for money. You can't force somebody to employ you in Ghana. So you can't sue the person to re-employ you, but you're suing for damages. Okay, so Jemima is
All right.
saying,
Thank you, sir.
can you repeat the 3 exceptions to a breach of natural justice? Jemima, there are 3. 1 is waiver of rights, when you fail to speak out. 2 is necessity. Necessity means there's no option but to stick to that judge. And 3 is legal or statutory authority, which means that the law says a certain person should perform a duty without giving a substitute. Remember, we stated natural justice is justice in accordance with the law. So you can't depart from the law. Yes, I have a question. Will you share the slides? Yes, it will be on YouTube. So don't worry, I'll share the link. Thank you very much for today's conference. All protocols observed. I'm saying so because I don't know if the protocols will want me to state their names. Please, all protocols observed. Thank you very much. We shall meet for the next conference, which shall be soon, the closure of the year. Please enjoy your evening.
Thank you, Nana.